Hi everyone, I am SUSWANI, intern BSK Legal. Today I am going out of my way to elucidate the concept of necessity as a defense. This concept is enshrined in the maxim necessitas non habet legum, which means necessity knows no laws. What is necessity defense exactly, and under what circumstances might it work in the law of tort? As in the case of Banda versus Bannett, a fight broke out in a maximum security prison and the prisoners threatened by death. Because of this, they broke out of their cells. Surely they are not guilty of the crime of escape. Here is a situation where most of us would agree that necessity could be a defense and that the prisoners who broke out of their cells out of necessity ought not be convicted for escape. The defense of necessity recognizes that there may be situations of such overwhelming urgency that a person must be allowed to respond by breaking the law. Necessity is based on the maxim Salis Populi Suprema Lex, that is, the welfare of people is the supreme law. Necessity as a defense is defined under Section 81 of IPC, that is, act likely to cause harm but done without criminal intent and to prevent other harm. Nothing is an offense merely by reason of its being done with the knowledge that it is likely to cause harm. If it be done without any criminal intention to cause harm and in good faith for the purpose of preventing or avoiding other harm to person or property. Basically, these are the essentials. And the act should be done in the good faith without any mens rea, that is criminal intent. The intention of the person doing that act should be to cause smaller harm to avoid or to prevent such greater evil and to person or property. So let's take an example. A, in great fight, pulls down houses in order to prevent the conflagration from spreading. He does this with the intention in good faith of saving human life and property. Factors affecting necessity. Necessity is an affirmative defense that a defendant invokes the defense against the torts of trespass to chattels, trespass to lands, or conversion. With the necessity defense, there will always be a prima facie violation of law. Here, the burden of proof will be on the defendant. He should prove four things. There is reasonable belief that he reasonably anticipated a direct causal relationship between the conduct and the harm to be averted, and there is no realistic alternative, that he had no legal alternatives to violating the law, no greater harm caused, no involvement in the threat, and they were forced with a choice of evils and choose the lesser evil. They acted to prevent imminent harm, as we said it, like greater harm. Now coming to types of necessity. There are two types of necessities, public necessity and private necessity. Let's now discuss about public necessity. Public necessity pertains to the action taken by public authorities or private individuals to avert a public calamity. The classic example of public necessity is the destruction of private property to prevent the spread of fire or disease and hence to avert an injury to public at large. Like as in the said example, where the person pulls down destroyed his house to prevent a greater harm. And now coming to the first case which was filled with reference to public necessity was Sirocco versus Gary. With this illustration, public necessity is being defined: a ship which had run into difficulties found it necessary to discharge her cargo of oil, thereby polluting beaches which belonged to the plaintiff. Since the discharge of the oil was necessary to save the crew and not only the ship, it was accepted that the defense of necessity applied. Now, coming to private necessity. Private necessity arises from self-interest rather than from a community at large. It takes place when the defendant wants to protect his own interest. It does not serve as an absolute defense, as in the case of public necessity, where public necessity serves as an absolute defense. And here, private necessity can be explained with the following example, like if a defendant entered upon his neighbor's land without his consent in order to prevent the spread of fire into his own land, the principle applied for private necessity is necessitas inducit privilegium quod jura private, means necessity induces a privilege because of private right. This maxim makes it clear that private defense is more kind of privilege enjoyed by many persons. The earliest case of private defense was Vincent versus Lake Erie Transport Corporation. There is, however, a third group of case which is also properly described as founded upon the principle of necessity, which is more pertinent. These are these are concerned not only with the preservation of the life or health of assisted person, but also with the preservation of his property and even with certain conduct of his behalf in the administration of his affairs. Now coming to the importance of this concept, necessity as a defense. Necessity incorporates flexibility into laws that would have been led to unjust results. The defense of necessity applies to situations where torture is morally justified, like in the case of a prisoner who breaks the prison and runs away because he was mentally and physically tortured by the prison authorities. Necessity provides relief in situations pertaining to this. Necessity defense has the effect of allowing one who acts under the circumstances of necessity to escape criminal liability. Perhaps the necessity defense should be thought of as a moral provision for mal in se offences. Mal in se offences generally protect against harms to others, and to the extent that the necessity defense defines situations in which one may harm others. Limiting the necessity defense. The defense of necessity scope has been limited. Like, necessity defense restricts the ways in which private citizens may use force that harms another's interest. The limited scope of necessity defense is one of many tools that help sustain the state's monopoly on legitimate violence exists to empower individuals where individuals are supposed to be powerless, and it cannot be used to confer powers on the state as well. After all, the government powers is greater than what is allowed to private individuals. And under the necessity defense, and the greater state's monopoly on violence must necessarily include the lesser individual's use of violence. Now coming to the how this concept looked up by the courts. If a court determined that a given offense was regulatory in nature, the nature authorizes a necessity defense. If none were present, the defense would not be allowed, obvio. It carries the implication that violation of given rule is positively desirable, thus turning it into a standard. Common law necessity requires that the harm be truly imminent. The allowing defendants to use the necessity defense in regulatory cases will tend to distract courts from employment of other common law defenses. The cases where courts have expressly ruled on the necessity defense availability, either on the facts or as a matter of law, can be roughly divided into three main categories as stated in the PPT. The first is that grant a jury instruction on necessity and allow the defendant to prevent evidence concerning it. Now, there is no jury. It has been ended in the case of K.M. Nanavati. Now, coming to the second point, find the defense incompatible with the offense involved. Or the third point is obvious that defendant failed to prove, like to meet his burden of proof on at least one element of the defense. Now, coming to, as we said previously, trespass to chattels, trespass to land, or conversion. With the necessity event, there will always be a prima facie violation of law as stated earlier. The violation will consist of trespass, conversion, or other kinds of infringement of property rights. A major issue associated with both private and public necessity is whether compensation is owed to the aggrieved party whose property is damaged, appropriated, or destroyed. However, compensation must ordinarily be paid for any harm done in this process. Now coming to the conclusion and my observations by researching in this concept, the observations one can reach is that necessity considers circumstantial morality and provides one to be saved from his circumstantial offense. Necessity else than being a new defense is also an evolving concept, which one can see through the Vincent case and as well as R versus Dudley and Stephens case, which cleared some essentials regarding it. The way it evolves will depend on how the judiciary interpret in the future cases. There is no doubt that it has attracted some criticism and which also do some sense, as it was in obiter dicta in R versus Dudley and Stephens, where it was said not every necessity can be ground for necessity otherwise. There will be utter covers and nothing else. This inference of the judge seems very true for me. And thank you, Sanjay sir, for giving me this opportunity. Thank you so much.